thank you very much for giving me the opportunity to be here today and share some of my thoughts on the latest amendment to the Danish Corporate Governance Code from 2020, which included a recommendation on company purpose. And as far as I see it, this recommendation leaves us with at least two questions, many more, but I'll mainly touch upon two today. First of all, what is the purpose of introducing such a purpose recommendation? And the second question being whether it has any company law effects. To give you a very brief background on the Danish Corporate Governance Code, the first code was published in 2001 and it has been updated 10 times since then. And the latest amendment was in December 2020. When the first Corporate Governance Code was introduced in 2001, the committee that drafted the code found that companies and civil society play an important role in relation to questions on ethical, social, and environmental considerations that traditionally have been safeguarded by public law. And furthermore, the committee found that for companies to fulfill this role, soft law should be preferred to hard law because this would allow companies to take a self-regulatory approach where they can engage in these areas. And we have seen several examples of that in Denmark throughout the years. And lately, we have found at least two examples in the 2020 amendment. First, the recommendation on company purpose, which I already mentioned, but there's also an amendment to the recommendation on the CSR policy, which now includes social responsibility and sustainability to be areas that should be included in that recommendation, or that policy, sorry. And moreover, the new Corporate Governance Code includes a section with definitions and explanations, and I'll get back to that. So, besides these amendments being interested in the framework of the original ideas of companies taking a responsibility in relation to areas that are traditionally safeguarded by public law, these two recommendations are also interesting for a number of other reasons. One of them being, as Ian already mentioned, that we have had a very lively international discussion on these areas, company purpose as well as sustainability. And therefore, it would be natural to expect that the Danish Corporate Governance Code in some way was affected by this debate. Today, however, I will only focus on the recommendation on company purpose and look at what kind of effects we might expect it to have. As mentioned, at least for the last 5 years, we have had this really lively international debate on company purpose. And as Ian mentioned, it partly was sparked by BlackRock CEO Larry Fink's letter to CEOs in January 2018, and it has been followed by other statements as well. And they all emphasize the importance of companies in a social context where long-term value creation should benefit not only shareholders, but also company stakeholders and society at large. And in academia, in particular, the British economists Colin Mayer and Alex Edmonds, as already mentioned, has been very strong advocates for corporate purpose to be the driving DNA of companies. But interestingly, even though the Danish amendment took place at a time where we did have this international debate, the amendments were not discussed at all in Denmark, including the company purpose. So it actually leaves us without any guidance on how we should understand this new recommendation. And therefore, it's interesting to look into the recommendation itself and the definition to see if we can find any kind of clues there to how we should understand the new recommendation. So to give you an idea of what the recommendation looks like, it's copied here, and as you can see, it's included in the section in the Corporate Governance Code that deals with the duties and responsibilities of the Board of Directors. And as you can see, it says that the committee recommends that the Board of Directors, in support of the company's statutory object, and the long-term value creation, should consider the company's purpose. In the code, each recommendation is followed by one or more comments explaining the particular recommendation. And if we look at the comments that follow this particular recommendation, it is said that The company's purpose will often take into account its relations to the shareholders, other stakeholders, and society in order to contribute to attaining the company's statutory objects and to create long-term value. Moreover, it's said that the company's purpose is pursued on a daily basis through the company's culture and values, and the board of directors should ensure coherence between these. So that at least we have two places where we can find guidance on how to understand the recommendation. But we also find something in the definitions, because being a new purpose, this is included in the section with definitions. And here we can see that a company's purpose is the company's overall aim for long-term value creation, which the company delivers to shareholders, other stakeholders, and society. And in order to support the company's statutory objects, the company's board of directors should consider the company's purpose. Moreover, it's said that many companies already have a purpose, which they use actually in the company's strategy, for instance, under the designations mission or vision. And finally, it's said here that the committee considers the company's purpose to be a considerable driving force for the company's strategy and the decision-making process. So we get a lot of information on how we should understand this recommendation, but actually it repeats itself a little bit and it points in different directions, so it doesn't really make us any more enlightened on how to understand this recommendation. And to highlight some of the different direction that it gives us, it talks about the overall aim for long-term creation of value, and it should be delivered to shareholders, other stakeholders, and society. It should also support the company's statutory objects. It should be pursued through the company's culture and values. And it also says that we know company's purpose already, just under different designations, such as mission and vision. So it at least points in two directions. First, we have some legal implications because it's attached to the company's statutory objects, but it also points in a more strategic direction, talking about strategy and vision and mission. And there's absolutely no mentioning of the international debate, so it's really difficult to see if there's any link to what is already being discussed in a broader perspective. So if we start by looking at company purpose in a legal perspective, the obvious question is, how should we understand purpose in relation to the company's statutory object? The statutory object in Denmark is regulated by the Companies Act. And the object can be defined in a wide or a narrow sense, but it must give some indication as to the nature of the business of the company. And that's really important because it allows shareholders, creditors, and other stakeholders to assess the risk that may follow from the nature of the business. But it also has a legal purpose because it lays down the objectives for which the company has been formed, and it defines the scope of area for the company's operation, and thereby it also limits the acts of the board of directors. What we can read from the recommendation is that the purpose should not be confused with the statutory object, because it's said very clearly that the former should support the latter. So the purpose should support the statutory object. But it doesn't really give us much guidance as to how we should understand company purpose. But if we try to look at an example to get an idea of how they may differ, I chose Carlsberg Brewery, which I think maybe a lot of you already know. And here you can see on your left hand, I guess, the statutory object, which you can see describes the nature of the business in a very descriptive and objective manner. This is what we do. And if you look on the right side, you can see the company purpose. And essentially it says that by brewing beers, we can create a better tomorrow for all of us. So that is much more open and much more philanthropic, but it's very difficult to see how it will support the statutory object. But if I should give an interpretation of the connection between the two, I would argue that the statutory object has to do with the what. What do we do? What is the business purpose? Whereas the company purpose has to do with the why. Why do we do this? Why do we engage in this kind of business? So they are totally separate when we look at the legal nature of these two, at least as I interpret the two. And if we move on to see if there are any other legal implications, the first question that arises is who has the power to adopt such a company purpose? And the recommendation says that in support of the company's statutory object and the long-term value creation, the board should consider the company purpose. So it's not a recommendation recommending that the company adopt a company purpose. Rather, it assumes that the company already has a company purpose. So it doesn't really answer the question who should adopt it. But I think the many references to the strategic level and the company's mission and vision suggest that it can be adopted by the board itself, and it's not something that has to be included in the Articles of Association, and therefore it's not something either that has to be presented to the general meeting. But of course, the board of directors is free to present it to the general meeting. They're also free to adopt it, at least according to Danish law, in the Articles of Association. And a shareholder is also free to propose a company purpose to the general meeting, no matter the size of their shareholding. And if 2/3 of the general meeting approve, they can enter it into the Articles of Association. But as far as I know, until now, no Danish companies has adopted it in the Articles of Association, and that would also support that it is the board of directors that has the power to adopt such a purpose. So the next question is, does this have any effect on the management and the board duties? It talks about considering the purpose, and the purpose being a driving force in the decision-making process. And as far as I see it, it doesn't really bind the board of directors in any legal way. But we could also consider if there's any normative guidance to the board of directors in how the company should be run. And this is relevant when we talk about the why. Why do we do this kind of business that we do? But looking at the recommendation and the definition, there are absolutely no normative indications. This could be linked to the initial ideas of the committee that companies should self-regulate in these areas, so the why should be defined by the individual company itself, so it should sort of set out the direction that it should take. But we don't find any normative indications in the recommendation itself. And the last legal question that it might raise is related to the fundamental question, for whom is the corporation managed? In a Nordic perspective, it's interesting that although there are many parallels between the Nordic Company Acts, they differ in the wording on this fundamental question. While the Finnish, the Swedish, and Norwegian Company Acts all state that the purpose of the company is to make profits for its members, the Danish Company Act does not contain a similar provision. However, it's an implicit understanding in Denmark that the primary purpose is to create value for the company first, and then second for the shareholders. But that profit should not be misguided for company value. And when we talk about value creation, it should not be only for the shareholders, but also for stakeholders and for society in general. And in that respect, you may say that the addition of this recommendation to the Corporate Governance Code does add some value, because it makes the implicit understanding more explicit. But in general, you can say that the legal implications of this recommendation is very, very limited. So turning to the strategic implications, I think we might find the answer here as to why there hasn't been any debate in Denmark, because it's said, quite frankly, this is not something new. This is something we already know. We just use different terms. We talk about vision, we talk about mission. So why discuss it when it's something that we're already familiar with? But turning to my conclusions, the first question, what is the purpose of including such a purpose provision? If my findings are correct, that this is really not something new, then you can ask the questions, why do we want to introduce it to the Corporate Governance Code if it's not introducing anything new at all? So the first question is still really open to me. I really don't know how to answer that. I think we can say, though, that the provision has strategic rather than legal implications. And then finally, I just want to touch about my first comments on the initial Corporate Governance Code for 2001, where it was said that soft law was better suited for accommodating the changing expectations of society. So if this was the idea of introducing it, one would also expect that there would be something new behind the code. And since there is not, we can't really see that this is going to change anything at all. So I think my final conclusion is that the introduction of a company purpose in the Danish Corporate Governance Code is just business as usual. Thank you.